Good afternoon. Last night I found myself wondering what could possibly be better than a consultation on our approach to financial penalties. And today I have the answer, and that is a second consultation on our approach to financial penalties. So that's what we're going to be discussing in today's webinar. Why are there two consultations? Well, in the first consultation, we established the principles around our approach. And now the second consultation digs into the detail of what that means in practice. So, for instance, in the first consultation, we decided that means testing for fines for firms and individuals was a sensible approach. But our second consultation proposes what that would look like in practice. So, what are we going to be covering today? Well, if you see on the slide here, we're going to be covering four main areas: our increased fining powers. Secondly, changes we're making to our internal processes to provide additional assurance around our decision making. Thirdly, how we approach our means tested fines. And finally, how the new fixed penalties will work. So to do that, I'm joined by Chris, Jen and Nabila. It's a score draw when it comes to the number of solicitors versus non-solicitors, 2-2. Both Jen and Nabila are solicitors. Jen heads up our legal team and Nabila our adjudication team. But Chris, who's our Director of Policy, has a wealth of experience in the legal sector and legal regulation as well. So you will have the option to ask questions throughout this webinar. You can start asking them now if you want. Click on the link below this webinar and we will try to get to as many questions as we can as we go along. It's nice to know your name if you submit a question, but you can submit them anonymously. So before we jump onto the detail of the current consultation, perhaps it'd be worth reminding everyone what we decided on the back of the first consultation. Now, we engaged with 7,000 people during that consultation, and it's probably right to say that broadly there was broad support for what we proposed, particularly amongst members of the public, but also across the profession. Of course, there's some nuance to that. There were some things that people did disagree with, and I think one of the main areas of feedback was that, well, if you're going to increase your powers, then it's important that you're even more transparent and accountable in terms of the decisions you make, and we'll pick up some of that in our conversation. But if we go on to the next slide, you'll see there was 4 key decisions we made coming out of that consultation. The main headline grabber was probably around our fining powers. We've already been able to fine alternative business structures up to £250 million, I think it is, but for traditional law firms and individuals working in them, we've been able to increase our fining powers from £2,000 to £25,000, and that's already been brought into effect by legislation in the summer. And the logic there is that we think we'll be able to get a better balance in terms of our powers. In terms of the most serious issues, will still end up going to the tribunal, but will enable us to resolve other issues more quickly, saving time and cost and also stress for everyone. One sort of misperception that emerged during the initial consultation period on that was some people were worried that an increase in our fining powers might be incentivize us and benefit us through us bringing in more money. So I suppose it's worth being clear that any fines we levy or that the tribunal make, they will go to Treasury. So then the second point on there beyond fines was we did make the decision, as I mentioned, that fines should be means tested for an individual or a firm. Again, there was broad support for that, but there was some debate about what that means in practice. For instance, should it be linked to turnover or profit? Then the third one you can see there, we set out some behaviours that we don't think are suitable for a fine. Particularly, we concluded that financial penalties for things like sexual misconduct, harassment, discrimination are generally not going to be appropriate, and they'd only be appropriate in exceptional circumstances. And then finally, we proposed to introduce fixed penalties for lower level administrative breaches. So for instance, that might be failing to comply with an information request. And we think this will have the advantage of enabling cases, again, to be processed more quickly, but also provides upfront transparency around what penalties would be for certain offences. And behind all this, we agreed a number of principles. Most of them are sort of hopefully make sense. For instance, that everyone should be treated consistently and that our fining framework should be transparent and proportionate. So that's very much the foundations as we move on to the second consultation, and I suppose the foundation of the discussion I'm going to have. So what I'm going to do is I'm going to have a chat with Chris, Jen and Nabila, talk through some of that, and again ask you, put your questions in, and we'll try and feed those in. So perhaps shall we start with you, Chris? And I think the SRA's had a significant increase in fining powers, as I've just set out. Can you tell us a bit more about what that means?
Yeah, so I mean, we welcome the decision by the MOJ to increase our fining powers to £25,000 for traditional law firms and those individual solicitors and those working within them. It'll allow us, as you touched on, to make straightforward decisions in-house and to agree more outcomes internally. And it is a significant increase compared to what we had previously, £2,000, but it's still a moderate amount compared to many regulators. And as you say, for alternative business structures, we have much higher fining powers at 250 million and 50 million for individuals. So some stakeholders did raise concerns or challenge slightly around us having those higher fining powers, questioning sort of transparency and robustness of our processes. So we've given careful thought to that. You know, we have these fining powers already for alternative structures. We have a lot of stuff in there already, but we do accept, you know, with higher fines, it's a greater responsibility and a greater expectation around accountability. So what we've tried to do is be really clear about what we already have in place and the safeguards in place. For example, we put some stuff that we have in processes. We're proposing they'll go into rules to just make it really clear. And we are also intending to enhance our safeguards that we have in place, and we've published details of that in the consultation.
Thank you, Chris. Perhaps I could come over to you, Nabila, then, and in terms of these enhancements in order to provide additional assurance, could you tell us a bit more about them?
Yeah, sure. So some of the proposals that we're looking to introduce are a requirement that the most serious fines must be imposed by adjudication panels. So currently adjudicators make all decisions in relation to fines, but those proposed within the table within Band D, which are the most serious, would only be decided by adjudication panels. So that's one enhancement. Something that we do already, which isn't actually clarified or set out explicitly in our rules, is that anyone who makes a decision, or any adjudicator that makes a decision at first instance, if that's reviewed or appealed internally, then that review or appeal is decided by a different adjudicator, and the same with adjudication panels. So if an adjudication panel makes a decision in respect of a matter and that's reviewed, then that will obviously, in its best practice, go to a different panel. We do that already, but we're proposing to set that out explicitly in our rules. Also, disputes requiring cross-examination, or there's a public interest in there being a hearing. There is proposed criteria within the rules that is more explicit, which more explicitly sets out the criteria for holding a hearing. And also that an adjudicator or an adjudication panel can direct that there is a hearing if one is necessary. So that's something that we're consulting on as well. Another enhancement is that we'd like to make it clear when an adjudicator or a panel can interview a respondent, a solicitor, or an employee of a law firm against whom we're taking action. And also when we may want to interview a complainant or another witness. So there are criteria within the rules where it's set out how we propose to do that. And then finally, providing a more streamlined process for revoking a referral to the SDT. At the moment, we are asked by individuals, and we may also decide that once we've referred an individual to the SDT that we want to revoke that referral for whatever reason. And the process at the moment is that we write to the individual and invite their representations, which can be quite long-winded and is probably unnecessary. So we're suggesting that that's a more streamlined process. Another enhancement or clarification that we want to introduce is updating our schedule of delegation, which is quite a technical table, which is published on our website at the moment, and it sets out all our decision-making powers under various bits of legislation, rules and regulations, and also who can make those decisions within the organisation. A lot of individuals can make decisions across the organisation, not just adjudication. And what we want to do is review that schedule of delegated powers to make it a bit more user-friendly and easier to understand and less technical. So that's something that we're looking to update. And as is the case with all our rules and regulations and proposals, we'll keep those areas under review. And if there are further enhancements or improvements that need to be made, we will undertake those improvements or enhancements in consultation with others.
Thank you, Nabila. And I suppose that was one of the reasons we're consulting, because we want to hear people's views on that. Now, Jen, you're very much at the sharp end of this, working in the legal side, and presumably this has implications for both existing cases as well as also new cases. How are you dealing with that?
So we quickly operationalised the increase in fining power, and all open cases have now been reviewed. Where notices had been disclosed already making a specific recommendation or a decision to refer had already been made, we've been flexible in our approach. So we haven't changed any recommendations or reviewed any decisions made, but we have been having conversations with those regulated persons that are affected about whether they might rather have their matters dealt with under the new regime.
And has anyone taken us up on, the opportunity to be dealt with under the new regime?
Yes, so whilst everything is confidential, there's been 2 matters where regulated persons have been discussing the possibility of a regulatory settlement agreement with us. Yeah.
And what about those cases that are perhaps earlier in the sort of process and not so far progressed? What's happening with them?
So we've also been looking at all of those ongoing investigations as they're reaching notice stage, but where the notice hasn't yet been issued and the recommendation's not been made. We are currently using our existing sanctions guidance, which is as published on the website, and considering all of those cases alongside that published guidance to see how they're impacted by the increase in the fining power. And of course, what's absolutely crucial is that we're applying these powers fairly and consistently across all of those cases.
And presumably this has required quite a few internal changes in terms of how the team at the SRA works. What are you doing to keep them up to speed with what's happening, and what might now, in terms of a case, what might still be appropriate to go to the tribunal and what we might be able to deal with in-house?
Yeah, so given the need to operationalise quickly, we've been holding weekly case meetings with a team of lawyers and the investigation officers involved, reviewing all of those cases that are reaching notice stage. And that's been working really well for a number of reasons, importantly, not slowing the process down. We're also upskilling and supporting the investigation officers who are making the recommendations, ensuring that there's that consistent approach to the application of the guidance. We've also been identifying the type of issues that might still be suitable to be heard by the tribunal. And I think in the longer term, that way of working will also help us identify any key themes or trends that we're seeing, both in terms of those cases that we feel we are able to deal with internally and those cases still being referred to the tribunal.
So that's great. And we just going back to something you said previously, you referred to that some people have decided to switch to the new regime. Are there any cases where the SRA has made the call it would be appropriate to move to deal with it in-house since the changes?
Yes, absolutely. Since the new fining power regime was introduced, around a fifth of the notices that we've been reviewing and looking at have led to a recommended internal sanction. And all of those cases would have previously been referred to the tribunal. So with that brings all of the things we've talked about in terms of savings of cost, time and stress for individuals.
And I suppose on the back of that, and it's one question I get asked when I'm sort of out and about talking about this, is this going to mean that ultimately we're going to see fewer referrals to the tribunal?
I think it's clear that going forward we are able to deal with more cases that would have gone to the tribunal previously. But also, I think we need to bear in mind that there isn't a target figure of cases that have to go to the tribunal every year. And in our role, we know it's difficult to always forecast the type of case or complexity of investigation that we see coming through. So we're obviously at the early stages of the change, but we are definitely expecting to see the reduction of those cases that need to be referred simply because we didn't have the internal fining powers available to us. And
Yeah,
again, sorry, go on.
No, go on. I was going to say, it sort of depends what comes through the front door, doesn't it?
Yes. And again, the key thing is to reduce the time taken and costs wherever possible, but acknowledging the serious cases will go to tribunal.
Now, another, I suppose, concern that I've had raised with me, and particularly if I'm speaking to perhaps sole practitioners or those who work in smaller firms, is there a risk that some people might feel pressured to accept a fine from the SRA because of the higher cost of going to the tribunal? And, what's your view on that? Is that a potential problem?
I can see why the questions are being raised, and costs usually recovered at the tribunal are higher than our internal costs. And that's why we think this increased power will be a benefit to those engaged in the process. I think we need to appreciate that people are motivated in many different ways and will make decisions about their case on an individual basis. One of the factors might well be an early resolution is better for them. I think, though, what's important for us is that we need to ensure that whatever that person's motivation or reasoning for the decision, we're applying high standards across all of our investigations, ensuring that we're presenting sound evidence upon which to base those recommendations that we're making in the investigation teams, and ultimately sound evidence upon which a decision maker in Nabila's team can ultimately make that robust finding. I think it's, as Chris mentioned, it's worth noting it's not entirely new for us. We've had regulatory settlement agreements and higher fines for licensed bodies for some time now. So, it's not new. I do understand, though, that there are reassurances we need to make around our processes, and Nabila's covered those enhancements proposed. But we do already have checks and balances in place, and we have clear published processes that we follow. So this isn't about making fast or loose decisions. These will be recommendations based on the evidence throughout the investigation stage, and importantly, upon which the regulated person has had an opportunity to respond.
And I suppose it's probably worth mentioning, I'm right in thinking that people can still appeal a decision. That's right, isn't it, Jen?
Yes, all of our decisions are appealable. So if someone thinks that the decision isn't right or is unfair, they have that right to exercise the right to appeal. I recognise, though, that the cost of making an appeal would deter some. And so our focus, in my view, should and always is clearly on getting the right outcome first time.
Thank you. Should we come back to you, Nabila? And I suppose I wanted to go back to the issue of transparency, which again was a big issue that was brought up in the first consultation. And some people are concerned around the SRA being what I suppose some people would describe as judge, jury and prosecutor. And, does this go too far?
I'm just unmuting. Yes, I mean, I'd like to point out that it's not unusual for a regulator to set the rules and investigate alleged breaches and also determine the outcome. That's something that's happens across other professions, for example, doctors, nurses, architects, teachers, to name a few. I'd also like to point out that unusually within the legal profession and for solicitors, we don't internally have the power to strike off or suspend a solicitor. That decision can only be made by the tribunal, as well as fining an individual over £25,000. So that's what I'd like to highlight in relation to a response to us being judge, jury and prosecutor. But also internally, the adjudication team is functionally separate from the investigation team. And what that means is that we make decisions independently of any investigation and based on the evidence that's been disclosed to the regulated person. So we don't see the whole file, we only see the information and the representations that have been disclosed, and we make decisions based solely on that evidence. As I've said, we've introduced or proposed additional safeguards across both the investigation and the adjudication function, and we'll consider suggestions for further measures to improve our transparency. We're also currently considering our approach to publication of regulatory decisions, which is part of our transparency in improving the openness and our decision-making process. And we're working through those responses at the moment, and we'll be publishing the outcome and our approach. And I reiterate, we'll keep those measures under review, and our post-consultation position paper will be set out once the consultation concludes next month, as well as our ongoing plans for evaluation, including reporting on our proposals if and when they are introduced.
Thanks, Nabila. One thing I think you mentioned around that sort of assurance process was that the adjudication team is separate to the investigation side of the SRA, which and the legal side. I suppose some people might cynically say, well, is that just a rubber stamping exercise, or is it the case where you disagree? Do you not back recommendations from the investigation team? How often does that happen?
Yes, absolutely. It's not a rubber stamping exercise. We take our sort of impartiality and functional separation very seriously. So we are a check and balance, and we will make decisions, hopefully robust and clear decisions based on the evidence. So we do regularly go back and make findings in relation to the allegations that are made against individuals, but equally we may not find allegations approved on balance of probabilities. If we do find allegations proved, we don't necessarily always follow the recommended sanction or outcome. So we will look at mitigation, aggravating factors, the context, the facts and circumstances of the case, and make our own independent decision. So I would reiterate, it's absolutely not the case that it's a rubber stamping exercise. And we do fairly regularly either not follow the recommended outcome in terms of a sanction or a control, or we may not even find the allegations proved.
Thank you, Nabila. That's really helpful to talk through. Chris, shall we come back to you? And I wanted to move on to, I suppose, the fining guidance. And the new fining guidance takes into account individual and firm income in all cases. Can you explain in a bit more detail our approach there?
Yeah, sure. So we've always taken into account a firm's turnover when issuing fines for larger firms with a turnover of over 2 million. However, for individuals and for smaller firms, we've set amounts up to a maximum of £50,000. So we didn't think that's the most proportionate or targeted approach, but you can imagine the impact and the extent that penalty might act as a deterrent will vary massively. So the impact of a £1,000 fine on a newly qualified legal aid solicitor versus a partner in a large city firm, obviously massive difference. Or how it would seem consistent for a law firm with a £1.9 million turnover to be fined up to a set amount of 50k max, but a firm doing exactly the same wrong thing would be fined a percentage of their turnover. So we're changing that. So fines will always be linked to means for all solicitors and all law firms, apart from fixed penalties, which we'll come on to later. For firms, relatively straightforward as we do this already for the large firms. So based on a percentage of domestic turnover, and we have also increased the maximum percentage for the most serious breaches. So a contract fine of up to 5% of turnover, which is currently 2.5%, which we think sort of offers more sort of credible deterrent in certain cases and brings us more into the normal range of many other regulators.
And that's very much, I suppose it's worth reminding, isn't it? Fines are very much about, it's the deterrent effect rather than there's not a punitive element to that. So you've talked a bit through what that means for firms. What about for individuals? Is it linked to their income?
Yeah, well, I mean, for individuals, this is new to us. I mean, there are different ways that you could do it. We got some external consultants to have a look at the different ways, and we are proposing that the fairest and best way is to base fines on a percentage of gross income. So if you use just an example of a B1 fine, so we have the 4 fining bands from less serious A through to D. If you take a B1 fine, which is 5% of income, so someone who's on £27,000 gross income, that'd be 1,350. It's 60,000, 3,000, 150,000, 7,500. So you see how it's different depending on how much you earn and the impact that's likely to have.
And just suppose there's a bit of colour to that. I sat in quite a few public focus groups where people were very firm or felt it was fair to have that. You know, if you're going to have a deterrent effect, it's not much of a deterrent if someone who's extremely, you know, earning an extremely large amount gets a similar fine to what a junior solicitor might get.
Yeah. And that came through clearly in the consultation responses as well, I think. Obviously, the exactly how that will work, and there's a lot of detail in the consultation paper about that. People have different views on, so really looking forward to reading those views in the consultation clauses.
Thank you, and I do see that there are a couple of questions coming in online, so thank you for that. We'll get to those, but just an appeal, get further questions in, and we'll get to those as well. So, Chris, one thing the consultation refers to is basic penalties. What does that mean?
Yeah, so it's the same as now. So you will get a basic penalty, but then that can be reduced by up to 40%. So for things like early admission, so if the harm caused has been remedied and there's been cooperation with the investigation. So that's the starting figure, but then that can be reduced depending on circumstances.
And yeah, one of the things I mentioned earlier was one of the changes we were making is around not giving solely financial penalties around certain types of breaches, such as sexual misconduct, and that wouldn't be appropriate. Is there anything the SRA's had to do to bring that into effect?
So conduct such as sexual misconduct, discrimination, and harassment, where we think there's an underlying attitude or behaviour that presents a risk to people. And that's not compatible with unrestricted rights to practice, so more likely to be a referral to the SDT to consider a suspension or strike off. So we have made that position sort of clearer in our enforcement strategy.
Thank you. And shall we move on to, I promised 4 topics, and we're moving on to the final of those topics, which is the fixed penalties regime. I suppose, again, how is that going to work? How's that process going to work, Chris?
Yeah, so it'll be fixed penalties for some lower level breaches, so where there's non-compliance with administrative requirements or failure to respond to our requests. And again, the idea here is that there's a simpler, swifter, and really transparent process, and making a clear and timely link between the conduct and the fine. So we're starting off with just a few areas and limited to firms to start with, and we'll test and evaluate that. So those areas are where there's not non-compliance with our publishing required cost or complaints information, displaying the clickable logo, so the stuff in our transparency rules, failure to provide information we request, such as declarations of compliance for anti-money laundering, for example, failure to make sure role holders are approved, so your compliance officers, for example, and not informing us when there's a role holder that we need to approve. So the way that we see that working is that we will we'll contact firms and we will give them time to comply, and if they don't comply, there will be, within that time, there will be a fixed penalty.
And just a reminder, and it was there on the slide, but what level of fine are we talking about?
So for first offence, be £750, and that will go up to £1,500 for further offence of the same type within 3 years.
Thanks. And I suppose the key point, just a reminder, is we're not talking about anything that's at the more serious end in terms of breaches. And I suppose that list there, I suppose, is it's things that hopefully are more black and white. There's not a complexity as to whether you've got the clickable logo on your website or not. So hopefully that can help. That means they're more appropriate for fixed penalties. Okay then. Well, we've had a few questions come in, so I'd like to move on to them. Perhaps I've probably got a question for you, Nabila, first, and thank you to Steve for sending this in. He's asked whether adjudicators are solicitors or are solicitors involved.
Yes, all the internal solicitors that we have, and there are 5 of us, including me, we are all solicitors and we're all practicing solicitors, so we have practicing certificates. On the adjudication panel, I have a mixture of lay and legal adjudicators, legally qualified adjudicators. Some of those are the legally qualified adjudicators are solicitors, some may be barristers. We have, I think, around 6 or 7 members of the adjudication panel who are legally qualified, and the panel is refreshed every 4 years or so. So if you're interested in becoming an adjudicator, look out for our recruitment exercise. There will be one early next year.
I love the fact you've got a recruitment exercise into this webinar, Nabila. And your first question in the interview will be, have you watched this webinar? So we've got another question from Jeffrey. And I suppose earlier I was talking about fines are about deterrent. It's not punitive. But actually the main, in terms of us taking enforcement action, our absolute priority is public protection. And Jeffrey's asked whether our fines actions are separate from any criminal or civil outcome. Nabila, again, do you want to kick off on that, and anyone else can chip in?
Yes, they will be separate from any civil or criminal action. Sometimes what happens is that we're alerted to perhaps a criminal conviction that somebody has unfortunately been subject to, and that may engage our standards and regulations. So we will investigate those regardless of the outcome of the criminal conviction, and we will decide whether or not it does engage our standards and regulations and whether we want to investigate and take any appropriate action.
Thanks, Nabila. And we've had another question about disclosing papers to respondents in cases. Jen, do we disclose papers to respondents? Presumably we do.
Yes, so part of the standard process of an investigation is once the notice is prepared, which makes the allegations and refers to the evidence, that notice, along with all of the evidence, is disclosed to the regulated individual for them to review and make any representations that they want, or produce additional evidence at that stage to rebut the allegations made. And then all of those documents and papers go to the adjudication team for a decision.
Thank you. And we've had another question from someone who's asking where can they see the new rules. I think I'm right in saying the new rules, the details in the consultation. So that's where you need to go. And I'll probably repeat it again at the end, but it's the 14th of November, I think, is the deadline for that consultation. So there is a bit of time both to look at that and also respond on it. Okay, we've had another question just come in, And to what extent do financial penalties apply to a solicitor not holding a current practicing certificate? So Jen.
So obviously everything would be fact specific, but if that solicitor is still in on the roll and the conduct relates to their professional life, even if they might not be holding a current practicing certificate, then yes, we are able to look into that solicitor's conduct.
Thank you, Jen. Perhaps, Chris, I'll just come to you with one question, which we've been asked around personal impact statements. Where have those come from, and does that mean we're giving victims a greater role in terms of perhaps a say on sanction, or any role in the say on sanction?
Yeah, so this wasn't something we actually originally consulted on, but came through as a suggestion in a consultation response. And what we're proposing is to pilot a personal impact statement for cases involving sexual misconduct, discrimination, and harassment. So actually things are likely to go to the SDT, but there the impact is at the core of the harm. So at the moment we do seek information as part of the investigation. So pilot will add some better kind of structure to that and make sure there's consistency and transparency. So we're asking for views about that in the consultation, and then we would work up how that process would potentially work if we decide to go ahead with it.
Thank you, Chris. I'm not seeing any additional questions coming through. Thank you to everyone who both has joined us, and a particular thank you to everyone who's asked the question as well. I will thank you even more if you respond to the consultation. As I say, we've got to the 14th of November to reply to that. It's really helpful to get your feedback so we can refine our proposals and get them right. Talking of feedback, there is also a link below this webinar where you can give your feedback on whether you think this has been any good. Has it been useful? Could it have been improved? Be nice to Nabila, Jen, and Chris. You can be as harsh as you want with me, partly because actually I've had someone with a chainsaw and pneumatic drill outside my house. So apologies if any noise has seeped through, though I would like to clarify they are doing that in a work capacity rather than just somebody with a chainsaw outside my house, which would be very scary. But otherwise, thank you for joining us. I hope you have time for lunch now. I'll be going off to get a sandwich, but otherwise, thank you. Look forward to seeing your feedback and see you again soon.